Good afternoon, everybody. Today is June 6th, 2024, and we are here today to discuss constitutional issues in family law and child welfare cases. And today I have with me Brandy Thompson, who is an attorney with the Kronsick firm here in Lansing, and she's been there for quite a while, and she really has a lot of experience in the child welfare arena, although she does family law as well. And I also have Andrew Bossory, who's an attorney in Ann Arbor at Joshi Attorney and Counselors. Some of you may remember Ashish Joshi has been a guest on our webinars in the past to discuss topics such as parental alienation. And Andy has a lot of experience with the family law arena, especially. And the reason I brought both of these people on today was because I know from personal experience working on cases with them that they do raise constitutional issues pretty frequently in their cases. And it's such an important thing for us to consider that our clients in family law and in child welfare cases have constitutional rights. And sometimes we need to remind the court that they have been violated those rights. So here we are today with Brandy and Andy. Thank you so much for coming on. Welcome.
Oh,
Thanks,
well,
Lisa.
thanks for having us.
So I guess we're going to start with I kind of identified some different constitutional protections, and then we're just going to talk about some things that we've seen in cases and just kind of explore what we've experienced and maybe some possible fixes. And so remember, the audience, if you have questions, feel free to chime in with the chat or Q&A. So let's start off with procedural due process. So like the basic premise of procedural due process is notice and opportunity to be heard. So I wanted to see if we could talk about any cases that Andy or Brandy you have had where maybe your client hasn't been given appropriate notice of a proceeding.
Sure.
So I'll let Andy go first because I know that he's got something right on the top of his tongue on that one.
I do, and it's something that I'm seeing a lot of. And so one of the things that I sort of preface this by is that in addition to procedure, parents have that substantive due process right to the care, custody, control of their children. That's the U.S. Supreme Court. That's the Troxel case. And that filters down to the procedural stuff, which is your meaningful opportunity, not only for notice, but a meaningful opportunity to be heard as well. And that, I think, often is overlooked. There's a couple of cases that I cite all the time to sort of promote this. One is I think it's Bonner v. versus City of Brighton. That's the meaningful opportunity to be noticed and to be heard. And a meaningful opportunity to be heard that I'm really trying to advocate for is not simply the right to show up and talk then and there off the spot or on the spot off the cuff. It's that opportunity to be prepared to present a full and thoughtful and investigated case. And after digging a little bit in other cases, there's some really good support for the idea that this includes your right to meaningfully cross-examine people. Now, we all know that that's the Fifth Amendment right, or I think it's the Fifth Amendment, or the right to confront witnesses, the constitutional amendment, that really attaches to criminal cases. But there's a good case called Durant versus Stalin that says, I think it's a Supreme Court case, that cites U.S. Supreme Court precedent that really puts a lot of gravitas and weight into your right to cross-examine to get to an accurate result. So I really
even in the context of a civil case, it's not
a civil case, yeah. And I've been able to favorably rely upon that in a couple of different cases.
So Andy, I just to pause you for a second. I hope that you'll be able to share some of those case sites with us later. It doesn't have to be right now, but like this is actually a topic that I have not worked on before. So
oh, absolutely, sure thing. And what that means is you need to be able to present your case fully in a prepared way in custody decisions, parenting time cases. And where this typically, or I'm seeing a lot where this sort of butts heads with what's going on, is in the ex parte arena when it comes to ex parte orders to modify, suspend parenting time or custody. And what often happens, I'm seeing more and more of that, is a parent in a high conflict custody or parenting time case, whether there's alienation involved or not, raises some allegations in an ex parte fashion. They can be very serious allegations in an ex parte allegation. A court signs off on that ex parte order. And so a your client or a parent's rights to their care, custody, and control of their child are completely obfuscated or
Cut off, right?
cut off. That's
Mhm,
a better word. And you haven't had your day in court to challenge that. And where the real problem is, no matter what you seem to do, you can't get a timely hearing before the court that issued the ex parte order. Not only does that have the sort of actual day-to-day impact on the loss of your relationship with your kid, but if it extends long enough, you run into the issue that, wait a minute, when you finally do get your hearing, where you were at maybe a 50-50 joint ECE custodial environment at the time the motion was filed, when you get your hearing 6 or 8 months later, you're faced with an argument for a de facto change of the ECE, and your burdens of proof and standards have changed. And so you're at a consistent disadvantage. And
So, I apologize for interrupting you. I was just going to kind of dovetail just a little bit because from a practice standpoint, totally agree with you with regard to the entry of those ex parte orders. From a practice standpoint, obviously, if we're the one filing those ex parte motions, I've taken basically into putting into my ex parte request, the relief request, asking for an immediate hearing. And maybe, that might not go before the judge. Obviously, every ex parte in a family law case dealing with custody has to have that 14-day notice and everything. But I would say I'll pull out Eaton County just because I practice there regularly, and I know as seeing some of the people in the waiting room or the webinar today also practice in Eaton County, but I would pull them out as being kind of exemplary and I can't think of in recent memory an ex parte that either I filed or that another party filed where they did not, regardless of whether they granted it, whether they denied it, granted it in part, where it was not set for an immediate hearing before a referee of the front of the court. To get into court, you're going to have the opportunity to be heard, maybe even set for a longer evidentiary hearing. But they don't just sit back and wait for someone to file objections. And I would say usually it's within a week of when that has been entered, we're in front of someone, in front of the court, somewhere we can, see and figure out and make a difference. Potentially, or maybe make some movement on the ex parte order. And I think that, I know not all counties are going to have that availability to do that. I know that we talked when we were preparing for this, there are counties that have some room in their docket to do that, have availability to do that, and some counties that just simply don't. But I have found that, for purposes of ex parte, that really on both sides gives everybody an opportunity to get in on those emergency issues that we're dealing with very quickly and an opportunity to be heard. So I do like that. I'm not sure if it's practical for every county, but I do think that Eaton County is getting it very well done on that particular aspect.
Good plug for Eaton County.
And I would just ask Andrew one question with regard to those. Have you seen courts holding that the ECE has changed even on temporary orders, like on the basis of an ex parte being in place and not getting your hearings? Because I obviously I think that's a violation of the law. That there's lots of case law out there that says temporary orders should not be establishing an ECE.
I know, but if they last 6 months to a year or 18 months, it's who the child looks to. So I suspect that Andy's had a little bit of a different experience than what Brandy's had in Eaton County. So
I will say I am actively litigating a case where that is an issue before the court right now. And I'm working with Lisa's office to make sure the Court of Appeals is aware of the problems we're having, but I see it all the time. And I would just maybe add on to Brandy's comment, it's sort of an element of practicing what you preach. The credibility of what we as lawyers say in court matters. And obviously you take different positions on the factual issues of your case, depending on who your client is and whatnot, or arguing points of law different ways. But for fundamental legal premises, there's a consistency that needs to be had. If I'm going into every court complaining that I'm seeing ex partes filed without hearings attached to them, and I go in and do the same thing, well, more often than not, opposing counsel is going to be able to find out that, hey, this is very inconsistent. There's no credibility. So as sort of a matter of practice, in any ex parte I filed and the relief requested, it's set this matter for hearing as soon as practicable on the court's docket. And in the proposed ex parte order, I have just a line built in there. It is further ordered that this matter is set for hearing on blank for the court to fill in.
And then the question I have
Yeah.
for you, Andy, is when that doesn't happen, if it doesn't get set in 14 days or even like 30 days, like something that's a reasonable amount of time, even though that's beyond what the court rules say, what would your suggestion be? How do you, how to get it on the court's docket to have that hearing
This
that
is
you
where you
need?
have, yeah, this is where persistent. You have to be persistent and aggressive
Yep.
in a non-aggressive manner. I've had
Respectful manner.
a respectful manner.
Yeah,
I have
yes.
had to file, I peddled them demands for hearing, notices of request for hearing. If those are ignored, I've had to file outright motions for an evidentiary hearing attendant to ex parte order XYZ and set those on the court's regular motion docket. And you have to be consistent in doing those things. And I've had a variety of levels of success doing that. On occasion, I've had a simple email to the judicial clerk, obviously, or the attorney, obviously copying opposing counsel, so it's not ex parte, but saying, hey, we need a hearing on this. That's been successful. I've had to file a formal notice demanding an evidentiary hearing. That's been successful. I've had to go as far as filing an independent motion and getting on a separate docket. And if that's all ignored, you have a wonderful record to work from, that you've done anything and everything you could to try and enforce your statutory right to a hearing prior to or when an ex parte order has been filed or the court rules.
Right. So here we're talking about the hearing that happens after an ex parte, but in a related topic, what I see a lot of are temporary orders being entered that are based like on a motion to modify, that's based on the allegations in a motion to modify without with the judge not making factual findings on the established custodial environment or the best interest, which according to Man v. Man has to be done even on a temporary basis. I'm wondering, I'm thinking the same fixes that you're suggesting, Andy, would be that you basically do the same thing to get your hearing in that situation.
The same logic applies. Your
Yeah.
EC or custody order or parent time order has been changed without your hearing. And whether you're arguing that you're entitled to a hearing pursuant to the subsection of the court rule for temporary orders or ex parte orders, the fundamental constitutional right applies. The same findings with respect to the best interest factors need to be applied. And whether it was done entitled an ex parte or temporary, it has to be done. And where that I think becomes a little bit murky is when you have a motion hearing where the attorneys make argument on things on the motion, and then the court changes custody and parenting time and then tries to skirt the obligation to do those best interest findings by labeling it a temporary order. And that's where you just have to be prepared to follow up with.
Yeah, and I think for us practitioners too, if you see a judge doing that is, you're there on a motion, and I think we even discussed maybe even on a a different motion where the judge is modifying or making changes to the custodial environment, you need to put your objections on the record right then and there. Make sure that and cite your case law. Make sure the judge understands that they're not making findings if they haven't made the appropriate findings with regard to ECE and best interest factors. That the judge needs to go through those if they're going to be making those changes, and I think that you can probably use that as a basis to say, look, we need to set this for a longer evidentiary hearing, and so the court can go through and make those findings, and that'll give you time to get your witnesses lined up and prepare and be ready to go. You just make sure to put those objections on right then and there. We need to hold the judge's feet to the fire and not allow these orders just to be pushed through without making those findings.
And what I've seen a lot is where the temporary comes through and, you think you're going to get a hearing in 30 days because it's on the calendar. And so, okay, there's no reason to appeal right now. Like, yes, technically the order changes custody and our client's unhappy about it. We could do an emergency appeal, but that hearing's on the calendar, and the court of appeals, when they know that, they're less likely to be, they're less inclined to grant the relief. They're good about reversing if there's just, a complete absence of the procedures and there's nothing in the horizon that the court can see that it's coming. But if they see it on the calendar, like the referee hearing schedule or whatever, they're less likely to want to take action. But then we have the situation that arises all too many times where it's on the calendar and then it's pushed for 3 months and then another 2 months. And then like all of a sudden 8 months have gone by and still nothing has happened. I don't know if either of you have experienced that situation where the delays in pushing off that hearing for so long, that's really potentially impacting the established custodial environment.
Yeah, I mean, I will say I don't think I've had a lot of hearings, especially at the referee. Are you talking about the judicial level or the referee level?
Well, the cases I've seen have mostly been the judicial level, but like, yeah, hypothetically, because I think the referees across the state are more equipped. They seem better equipped to get those hearings started like more quickly.
Started.
Yes.
So yeah, the biggest area of delays that I see, I honestly haven't seen a lot in the counties that I practice of hearings being delayed or set aside or set back. I mean, obviously, I think we have to give the judges some leeway. They have emergency issues just like the rest of us. So I haven't really seen a huge amount of those hearings being delayed but I do see a lot of these hearings being pushed to the referees. They send it to the referee, they refer it to the referee, you hear it, we'll start a hearing, and then it might take, if you need 3-4 days of hearings to get through, it's taking 6-9 months to get those 3 to 4 days through. And I mean, I get it, their dockets are full, but I don't know how to stop that. But it is taking a long time to get some of these more complicated, complex matters that require, more witnesses than just the parties. Those are taking a long time to get through to the point where you're even going to see the judge or have a de novo or something of that sort.
I've had a similar problem in the FOC referee arena, and I mean, I see less of a solution there because the referee doesn't control the cases that are assigned to him or her. They get what the court refers, and they have to plug whatever slots they have available to their schedule and their busy schedule. So I think there's less room for a fix on that end. That being said, I still think there's a fix possibly at the judicial level on issue. Custody cases are supposed to be given priority status on your docket. They should trump or take priority over general civil, maybe even misdemeanor criminal. I think that they should be given that status. And I've made specific requests to judges when scheduling, for available dates. I've said, Your Honor, this is supposed to have priority status. Do you have any way to adjourn any less prioritized cases? Do you have a PPO review hearing that you can bump back? Or
so you're actually having that very direct conversation with court staff or
with the judge on the record. And it's actually,
I like it.
I mean, you got to be respectful about it, but again, I've gotten various responses. I've had judges then call in their law clerks and say, hey, what can we move? Can we push this or that? I've had judges say it's beyond me. You got to take it up with the chief judge and, go complain about scheduling there. But it's worth doing, and if you're able to do it in a respectful way. The other thing that I've tried to do, and I've been less successful with this, is ask circuit courts to exercise their discretion and not refer cases to the FOC. I've filed those motions to say, you have the discretion to directly address this case or controversy, this custody issue. When we go to the front of the court, it's going to exponentially delay the resolution of this case. We're going to have 9 months of an FOC hearing. Whichever party loses is inevitably going to object. That's going to add another month and then another 2, 3, 4 months to get the de novo hearing before you. Why don't we just avoid all of that and hold the hearing before the court directly? You have the authority to do that. Less successful with that because courts are busy, but
I was just going to say,
yeah,
we haven't had much success with that either.
And I still think, though, it's worth the shot, because one of the things I think, at least in the cases I've been dealing with at the appellate level, the Court of Appeals is starting to take notice of the fact that these cases are taking 8, 9, 10, 12 months to resolve. And if you make a record that you're providing options and opportunities to more quickly resolve a case, I think that plays to your favor.
Sorry, I just had a coughing fit. Relating to the delays, which I think is probably, I think we should start raising it more often, that the delay itself is creating a due process issue. I wanted to point out the court rule, MCR 3210, that talks about how after a motion's filed after the FIG-C hearing, or I'm not hearing, but the FIG-C meeting, sorry, I'm going to start coughing again. Right. The court, either the referee or the judge, has 56 days to hear the custody matter. It doesn't say start hearing the custody matter. It says have the hearing on the custody matter. Any comments? Like, I don't know, we should start, like, Andy, are you citing that court rule in your motions when you're having to push these motions forward?
I haven't, but I'm going to start. That's a more specific issue. And I think one of the barriers that I have with that particular court rule is just general docket management. A court could have the best docket management on the planet, and it could still be impossible to complete a hearing within 56 days just by the county that the judge is sitting in, the caseload, the volume of cases.
Understood. 100% understood.
I think when you try and hold courts to that degree of specificity on that issue, that's when you get the deferential treatment to the trial court by the Court of Appeals. They're doing the best they can. But it's unfortunate, it's when over the longer span, when those weeks turn into months and months, it really becomes apparent when cases are not being resolved in that timely fashion. And it's a different argument on its face to say you missed your 56-day deadline versus we're now 180 days in or a year in and we're not done.
And the other part of that court rule talks about after the hearing is done, after you conclude the hearing, you're supposed to have a decision within 28 days. And I mean, a lot of times judges are prepared to, or referees, they issue a bench opinion. So you just order the transcript and everything's right there. We have it. But what about when the judge is writing, opinions? Have you had an, I don't, 28 days.
It's 28. Yeah, I was going to say 28 days. I think that some courts are really good at it and some courts are just not. So that 28 days, we find, I'm fortunate enough to have a staff that hey, we need to call the court. We need to email them. We need to see where this order is. So we've certainly had to contact and follow up and, hey, is this recommendation coming? Is this order coming? Because we're waiting on it and it's past the 28 days. Practicing in the same county, you kind of have to weigh and whether or not you're going to file a motion with regard to that timing, especially if they say, oh, it's on my list of things to do. I'll get it out to you in the next couple of days. Do you file a motion or not on that? Probably not, but you, as a practitioner, you need to make sure that you are putting those dates in your calendar. And when that 28 days comes and you don't have that, you need to be calling the court and remind them, hey, put my case at the top of your stack. It's overdue. According to the court rule, you had 28 days. I think that's probably the most effective way to do that is reach out, like Andrew said, respectfully, of course, but you should be contacting the court and making sure that they're aware, hey, you're overdue on this. Where is that hearing opinion?
Have you had any success, like requesting a status conference to have a meeting with the judge and opposing counsel, and maybe get an update that way?
Yeah, I've done that. Ingham County, there's a couple judges that we were waiting on things. Maybe there's a lengthy transcript that the judge is reviewing. I would say because it's not negative, Judge Dunning's has been great. We had a case with a very lengthy transcript that I know that she had to read, as well as in Livingston County, where the judges brought us in for status conferences and said, hey, look, I'm still going through this. If you can, maybe cite to the transcript, provide us some direct requests of what they're looking for. That has been helpful to get them to the point where they're ready to make their opinion, instead of them just reading especially if you have a really lengthy transcript. That's a lot for those judges to get through. You know, so having them hold a status conference, say, you know, letting us know, hey, this would be helpful to get me to the point where I can make an oral decision or a written decision. Those status conferences have been helpful, and I think most judges are open to that. At least the ones
Be-
that I've requested.
Before we leave the topic of procedural due process, one of you, and I can't remember which one, I apologize, brought up the an example the other day of the friend of court sua sponte initiating a child support action or motion, and the judge put a uniform child support order through without any hearing or notice. Do you remember who said that?
It was Brandy, wasn't it?
Yeah, that was me, and it's actually, I mean, it was actually Kyle Brucker's case, who's sitting in the in the webinar today.
Oops.
And, you know, obviously, you know, in our office, we're always talking about these cases and trying to roundtable and figure out the best situation. But yeah, moving to set aside, getting a hearing. You know, when you see something like that come across your desk, and where did this come from? Why is the court issuing these without having any type of evidentiary hearing on it? You need to immediately file your motions and request for a hearing or to set aside
Did
something.
you do a motion under MCR 2612?
I honestly, that would be a question for him. I honestly cannot remember. I remember discussing that and saying, you know, look, we need to get something filed. And I don't recall exactly what the resolution of that was. But I do know that, you know, the discussion of we have to file something to get that heard and show the court. You can't just be entering these orders without having due process for the client, the opportunity to be heard.
Actually, I had one more question for Brandy before we leave the topic of procedural due process, just to see if you have any experience or examples to share in the child welfare context about an issue of procedural due process. And if you don't, that's fine. I didn't warn you about this.
And I think we've talked about that before. I've practiced in the Lower Peninsula in over 4 dozen counties. I think that the counties, in my experience on the cases that I have participated in, the counties are really good with providing notice, opportunity to be heard. They're very good about sticking to the timelines and requirements with regard to following the court rules on those timelines that they are required to do. The one thing I will say, those 63 days in the court rules, and I can't remember off the top of my head, but it is 63 days that they're supposed to adjudicate these cases. I can't think of a case in recent history where we've been able to successfully adjudicate or try a case absent a plea in 63 days. It's almost near impossible, but that is more so from my perspective, trying to get witnesses together, even finding an expert to review records in that short amount of time. So I wouldn't say that that's a court. I think courts probably could get us in and on the docket. But I think they recognize that most of us are going to need more than 63 days on these child welfare cases, because they often are complex and need, I can't think of very many that we wouldn't have expert witnesses involved to some extent, and 63 days is just near impossible. So that's the one timing delay thing that I frequently see.
And just to clarify, you're referring to the 63 days to get to the adjudication trial? Yeah. Okay, yeah. Which is like the first.
Yeah. Other than that, I think that most deadlines and timelines are met pursuant to court rules.
The one thing I would add, Lisa, on the procedural due process stuff is if you're taking a very aggressive position on enforcement of timeliness and scheduling and having your hearings, you need to be prepared to start an evidentiary hearing almost at the drop of a hat. What I see a lot of times is you make your objections, whether it's FOC, de novo, ex parte, whatnot, and you get a motion hearing set for that. Well, that's not what the court ruling contemplates. You're supposed to get that evidentiary hearing. And I've had hearings scheduled on the docket for a motion, and then when I make a point where this is supposed to be evidentiary, the court says, okay, go. And you have to be ready to do that. And the problem is, if you're not, well, then you're waiving your right to an expedited hearing. And then everything we just have talked about for the last 30 minutes kind of becomes moot. So that's a really important thing to be aware of, whether it's just having that conversation with your client. Hey, you might have to call you, be ready to go, and have that preparation done in advance. That's just something to be cognizant of.
So I think that's a really good point, Andy, because I think a lot of attorneys, like we contact the court to find out, hey, is this set for a motion? Like, is it set for 15 minutes? To the, and then if you think it's only been set for a short amount of time, you may not go through the preparation process that you would really need. And you might even have to have subpoenas or whatever issued if you're going to do it as an evidentiary hearing, but you protected your client if you are able to get prepared for whatever happens. And then basically, I don't know about demanding an evidentiary hearing that day, but you could even suggest to the court, hey, we're ready to go. Let's do this. and if the judge says yes, then you've eliminated a whole bunch of delay in the case.
And I wanted to make that point because in the last 4 or 5 months alone, this has happened to me twice, where there's been confusion, not just on my end, but with the scheduling clerk and opposing counsel as to precisely what the nature of this hearing is we're going to. We show up and lo and behold, it's the evidentiary hearing day without notice to any of us. Now, if you're the side with the ex parte in place in that situation, great. Let's get an adjournment. Let's get time to prepare. Let's get all the advantages out of that we can. And if you're on the other side, if you're not ready, there's an argument for waiver and you can't undo that. So it's a really important thing to be aware of.
I'm just going to add one more thing on this procedural due process is, and I don't know if Andy's experienced this either, but there have been occasions where you're set for an evidentiary hearing, you go in, this is only in front of judges, but you'll come in and say, okay, you have an hour. And that's, you have to, I mean, if you have 4 or 5 witnesses, you're never going to be able to get that in. I think that is a, fundamental violation of due process, in that is it a fair opportunity to be heard if you have 4 or 5 witnesses, but you get an hour and maybe the other side gets an hour, if even that, but then you're done. So I find that I believe that would be a violation as well. When you walk in there thinking, okay, I have all my witnesses lined up, everything, but you're so severely limited on time that it's basically a constructive violation of the right to be heard.
Yeah, and I've raised that issue before in a family law appeal. So I know we spent half of our time on procedural due process, but in fairness, those are the issues I see being raised in the trial court and on appeal a lot more than the other issues. So turning gears to the Fifth Amendment to the United States Constitution, particularly the right against self-incrimination. I know both Brandy and I have worked on cases where, for example, in a child welfare context, there was one case I worked on where our client was accused of injuring a child, but in order to be reunified with his own children, it was a different child, the court was requiring that he admit to basically committing a crime. And there was no criminal proceeding pending at that time, but he was denying that he did anything. And so before you can go home and be with your kids, you have to admit that you did something bad. And that was reversed by the Court of Appeals on the Fifth Amendment grounds. So Brandy, I think you have some similar experiences. I'd love to hear what you can share.
I'm drawing a blank on that case, but I certainly used that case as a basis and
Blakeman.
Blakeman, In re Blakeman. And I use that case as a basis in a recent case that I've had, but I think we see this in an NA in a neglect abuse cases in where someone has pled no contest. They haven't contested the allegations in the petition, and we move forward with reunification goals. And then the judge, lo and behold, says, well, I need to have some type of admission. The judge and CPS, for that matter, says I need to have some type of admission before I'm comfortable moving forward with unsupervised, let alone terminating jurisdiction at some point, which is essentially, that's your end goal, the reunification. In re Blakeman, as well as various, other state decisions, United States Supreme Court decisions, don't support that. They will say it's a Fifth Amendment violation to force a party, a parent, respondent parent, to make admissions, especially where and let's face it, in the vast majority of CPS cases, the allegations could certainly amount to some type of criminal charges on varying degrees of the spectrum, but absolutely could result in criminal charges, which is the basis for the no contest plea in the first place. I mean, the court has already made that finding that there's a basis for that no contest plea, and then turns around in the context of the dispositional review phase, the reunification phase, and says, well, we're going to throw that out the window. We need to have you admit to something. And it's not just admit to the court, but the case law supports that if he's saying, well, you don't have to admit this to me, or the judge is saying, you don't have to admit it directly to me, but you need to admit it in counseling, and take responsibility in counseling. The courts have held that is the same or has the same effectiveness as a violation of a Fifth Amendment right, because you're putting it out there, and those statements absolutely could be used against that party in a corresponding criminal case. So I think that we're making headway in that area. I hope so. But this is not the first case that I've dealt with where the court has said, you need to admit. And I think that is fundamentally unfair and a violation of a client's Fifth Amendment rights to do that within the context of a CPS case as a basis, as a barrier for moving forward, as provided and I think in Ray Blankman, as well as the case that I'm working on, the parent has done absolutely everything else, and the court even admits that. But the one holdup is that admission, and the case law in Michigan now that Liisa took through the Court of Appeals, as well as other corresponding state court cases around the United States. I don't think it's supportive of that. I think it absolutely does not allow these judges to say they have to make that admission in that context.
Andy, I thought you had an example that was a little bit of a twist on the scenario that we're talking about, with being forced to make an admission in a child welfare case, which potentially could have criminal consequences.
So I've had it both ways. I've had where an admission in a CPS case could very well lead to criminal consequences, which is, I think, what Brandy was commenting on. But I've also had it where any type of admission, or I mean, honestly, even the fact of cooperation with a CPS investigation has been used against a client in a parallel custody case. And so that really creates a difficult decision, because I think for the wrong of it, cooperation in a CPS investigation is oftentimes viewed adversely in a custody case.
Could you explain what you mean by that?
Sure,
cooperation.
Sure, engaging in a safety plan, engaging in therapy monitored by CPS, basically all the stuff that happens once should a CPS court take jurisdiction, all the things that need to happen to terminate jurisdiction to avoid that petition to terminate. And so when you do these things, these are used as arguments in custody cases to show deficient parenting or lack of a parent-child bond or connection, or pick the best interest factor you want to apply. And it's a very difficult choice to make, because if let's say you cooperate in CPS and you get that termination of jurisdiction, or they never even take jurisdiction in the first place because they don't file because you're doing what you need to be doing, you take the hit in the family case. Let's say you refuse to cooperate to preserve your rights and your ability to make your argument in the family case. That increases the potentiality or likelihood that CPS files that petition to take jurisdiction and terminate. And so it's a really difficult sort of path to weave. And I've had to have clients make that call, more often than I care to let.
I mean, how do you handle that situation? Basically, the client, you inform them they have to make a decision of which one's more important to them.
And we really have a big discussion on the strength of the case. If it's a very strong case, or we have very strong arguments to oppose the appropriateness of a CPS finding or taking jurisdiction, the conversation leans more towards, let's fight CPS. You get a trial there before a judge. You have your jurisdictional trial. and let's put our case there. Let's do it. And I've also had conversations where it's, it's a closer call, and it's probably better in this situation to accept that responsibility and plead for mercy with your family court judge, and you're learning and doing things, better and taking accountability and whatnot. It's a very factual dependent, call to make.
Any ideas of how to,
agree.
yeah, go ahead.
I mean, I agree. Certainly, I'm not, 100% certain about the constitutional effects of that from from a family law perspective, because obviously we don't have the same like Fifth Amendment issues, because there's no criminal culpability. But I think no matter what, I mean, CPS is because it's kind of smack dab square in the middle between criminal and family law cases, that there's going to be collateral consequences of a CPS case, whether it's just an investigation or an in-court case. Regardless, I've had less of an issue with regard to cooperation, having compliance and cooperation in CPS cases. It's more along the lines, I at least in my experience, did they say that the courts want to know, well, did CPS substantiate, or did they not substantiate? I see that a little bit more as a constitutional issue, because those substantiations, especially the out of court substantiations, that's a CPS worker sitting at their desk, filling out some paperwork and saying, yeah, I think they met a preponderance of evidence. In my mind, I mean, obviously a preponderance of evidence that's a legal standard. I'm not sure
Right, but it's not based on evidence presented in court, right? Or somebody legally, like a trained lawyer or judge, even better.
Yeah, you've never had an opportunity to be heard. It's not like you've got to present evidence and witnesses. I deal a lot with, and my office does, deal a lot with these out of court investigations, trying to, hopefully prevent these substantiations if we can. But yeah, you never get the opportunity to be heard before somebody's marking that box of, what category you are and whether it's substantiated or unsubstantiated. I see that probably as more of an issue in my mind than whether or not you're complying or cooperating with services. Sometimes it's actually worked to a client's benefit if they've done therapy or something of that sort. My biggest beef with regard to, if we're talking about maybe a constitutional issue, is this out of court, essentially finding of preponderance of evidence by someone who doesn't have a legal background, who, I mean, by all intents and purposes, from what I've seen in the testimony that I've heard from workers on the stand, get about 6 to 8 weeks of initial training, and then they're off, and then maybe they get some continuing education as they go through, but they really have no legal background. And a preponderance, if you're making a finding of a preponderance, that is very much a legal standard. And then we're taking that decision and then applying it as if it was a legal decision being made in the family law cases. So I mean, I see where Andrew is coming. That's to me is the biggest frustration, is, somebody sitting at their desk making this finding, and then using that as fact in the family law case, later, without really having any hearing on it.
There's actually good case law that says that the judicial court cannot just adopt the findings by CPS to modify custody or parent time. It can be something considered, but they can't simply say CPS substantiated, therefore I'm modifying custody or parenting time. Not only does that sort of outsourcing the court's obligation to be the fact finder and decision maker in cases, good case law on that point as well, but it is an end run around the court's independent obligation to do that best interest assessment or analysis before modifying custody. So it's like Brandy, like you said, it violates constitutional procedural due process in more than one way when that happens.
So it's definitely more egregious in the CPS context because we're dealing with, a non-trained caseworker, but that rule that you just stated, Andy, applies also to the judge adopting the referee recommendation, even though a referee obviously they're very well trained, have experience in family law, at least our attorneys, our quasi jurists, but a judge can't just rubber stamp a referee either.
And there is wonderful case law that says exactly that thing. And you know what? Judges are actually starting to pay attention to that. I've had many cases where more and more recently, where the judges are giving my clients a meaningful de novo hearing. It's not just I'll look at the record and rubber stamp whatever was said. it's that meaningful opportunity for, that full review, obviously with limitations imposed, depending on how things went. But they've been paying more and more attention to that, which is very nice to see.
Yeah, I mean, I feel like there's been enough published opinions about the errors created by a lack of a real de novo hearing that maybe that's what's getting their attention. But at the same time, there's tons of published cases that talk about not entering an order that changes custody without findings, right, and evidence, and yet we still see that happening all over the state. So it's something I can't explain. So I wanted to talk about First Amendment. And the way I've seen this, and if you have other examples, please, by all means, share them. The freedom of religion is what I'm seeing come up a lot. Not a lot, but when it does come up in First Amendment context, it's the freedom of religion. A lot of times it has to do with medical treatment or vaccinations. And I want to see if either of you could weigh in on that.
I'll let Andy talk if he wants to talk about it from a family law perspective. I have a lot to say with regard to the child welfare system.
I can be pretty quick with respect to the family law perspective. 9 out of 10 judges, unless you're in a very particular county, are gonna, particularly on the vaccination issue, are going to agree to vaccinate your children. There's no other way to look at that. That is the practical reality there. And so that freedom of religion right, yeah, it exists, but it's almost, I would almost call it an illusory right in the sense that it's not really enforceable. Because when it's an issue, judges are going to side with vaccination. And if you pick that as your hill to die on or to make your stand on, it's going to affect your credibility and goodwill towards the court for all of the other issues in the case, potentially more important issues. So before you place a stance on an issue like that, you really need to do that assessment of who's your judge. Think practically, how's this judge going to rule? And do we want to spend that judicial goodwill or capital litigating this issue? 9 times out of 10, and I've had clients that feel very, very strongly about the issue of vaccinations, but I've had to have that candid conversation with them. This is how it's going to happen. What's going to happen? I can make the best argument as I can. I can bring in experts and articles and research and witnesses. We're still going to lose this issue. And what that also means is the judge isn't going to pay as much attention to the other custody issue with respect to whether, and usually in my cases, undermining behaviors. The judge is going to pay less attention to that. And that's where we want the court's focus. So weigh that carefully.
Thank you.
And yeah, and I would just say from a child welfare perspective, it's obviously a lot of the same. I think Andrew and I agree. You have to pick your battles when it comes to that, and especially in both child welfare and custody cases. I mean, the biggest thing that the courts are looking at is best interest of the children. And if you have a judge that's predisposed to vaccinations or whatnot, and you're sitting there arguing to the court, well, we don't want the children vaccinated, and that's a big argument. You have to wonder, is that going to cause some level of bias later when the courts are factoring in, whether or not the parents are acting in the best interest of the children, making decisions in the best interest of the children. So that's something, I often have to have conversations with my client. I would say from a practice standpoint, if your client is absolutely adamant about vaccinations and their child has been removed, you should immediately file something with the court with regard to that, because before you blink, and if those children have been removed from the parents' care, they will immediately start setting up doctor's appointments, and those children are going to be vaccinated before you can blink. So absolutely get some orders or get some motions filed if that's something that your client is concerned about. Also, I'd say with regard to other First Amendment issues and child welfare, medical, just along those lines, medical treatment, it's often done with, without parents even knowing what's going on, dentist appointments, doctor. I mean, a lot of that stuff, most parents are going to consent to, but a lot of that happens outside of the parents. They're not sure when doctor's appointments are, whatnot. So I think that in my mind, is a violation. Parents should be involved in that, especially pre-adjudication issues, and even post-adjudication. Their rights have not been terminated. They should still be involved in those decisions. Freedom of religion, I can say from, again, a placement perspective, when children are placed, religion is, I can't think of any time that religion has been at the forefront, or even in part of the analysis of where they're placing a child. If a child is practices a particular religion or a specific religion, that's not something that's taken into consideration with regard to placement. Obviously, we have to look at family placement first. They're required, and ideally, family would have a similar religion, but we're not using that as part of the analysis when placing a child into foster care system. At least not that I have seen, and I would argue that maybe is a violation of religion if that child is not placed in a place that is at least conducive or supportive of a particular religion. It's usually just not even part of the analysis, part of the decision-making process, and I think that's faulty from a perspective of placing children. So I don't know if it rises maybe to the level of a First Amendment violation, but I think it's at least on the cusp of that.
So I know, Andy, you have court in just a few minutes, so I wanted to give you a chance if you had any other suggestions about how to fix these constitutional issues that are coming up in your family law cases before you shut off your screen and leave us.
Yeah, I think the biggest thing is, I think that initial point I made, you have to be diligent with your filings and your requests on the record, because if you remain silent, it's waived. And I mean, you can be creative in how you do this, however you want to title a motion, whether it's a demand for hearing or a motion for hearing or an email or a formal letter or a chambers conference or whatever. You just need to be aware that your client has that right to a hearing, and not just a boilerplate or limited or not in-depth or meaningful hearing. The due process clause provides you the opportunity for notice and a meaningful opportunity to be heard. So you have to really apply that word meaningfully. If it was just to be heard, well, then none of what we're talking about really applies. You get 2 minutes and you're done. It's meaningful, and that's getting more and more attention as we go forward. And thank you, Lisa, for filing some good appeals to get that going. But I often tell my clients this: if you don't use it, you lose it. And you can't come back 6, 8, 10 months down the line and say, oh my gosh, why didn't we do this or do that? You have to do it in real time as you're moving along. And that's the one thing I would impart. Just make those requests and be consistent and persistent with them, and don't let them go, because there's a reason for it, and they can bear results, particularly when you have a client that is not seeing their children.
Well, thank you, Andy. Yeah. Go to court, and I'll wrap up with Brandy.
All right. Thank you for having me, Lisa. Thanks, Brandy.
Thank you. Yeah. Thanks, Andy.
So
I would just add to what
ahead.
Andy said is not just motion filing, whatnot. Make your objections on the record as they're coming. I think I'm sure that was just a slight omission, but not just filing the motions but making your objections on the record when you're there, if something's happening and you believe it to be. I mean, worst case scenario, obviously it's denied, but at least it's on the record. And I'm sure that Lisa, from her perspective, from an appellate perspective, it's much easier for them when those objections are made.
So I thought of one more thing for the child welfare context. Because a lot of the procedural due process issues I think that we see in family law really aren't a problem in the child welfare context. There's different problems in child welfare, right? But one thing I thought about was, so let's just say we have all these parents who take a plea to the jurisdiction, right? And they admit to certain things in the petition that gets them to get services, because the whole idea is to get services as quickly as they can so they can be reunified with their children. And then when those services don't work out, the court, DHHS, will request to terminate parental rights. I've seen cases where the grounds for termination are different reasons than what were admitted to or proven at the jurisdictional phase, even if it was a trial. And I feel like that's like a violation. You can't admit to something and then use a different ground to terminate, without having I think you have to have a supplemental petition, right?
Yeah, okay. Exactly. They have to file. They cannot just move forward on the original petition. There has to be a different, if that original petition was the basis, they took they took adjudication and there's no termination request at that point, because you have to, if they're seeking termination at the initial disposition, it has to be added. It has to be on the basis for their termination has to be added to that original petition. There's separate statute for jurisdiction versus termination. So they're required to put you on notice and cite the basis for termination in that petition. So if there is a later petition, if either DHHS makes the request to file that supplemental petition to terminate, or the judge could order it if the judge, I haven't had that happen on any of my cases, but the law allows for the judge to order DHHS to file that supplemental petition, they would have to then put in those statutory requirements from MCL 712A19. They're going to have to put the basis, put you on notice, or the client on notice of the basis for that statutory, the statutory basis for termination, which is always a two-pronged test. They have to prove by clear and convincing evidence first that statutory basis, and then they also have to show that it's in the best interest for termination.
And really quickly, with the last couple of minutes we have left, is a pet peeve of mine in child welfare cases, and I suspect that you've seen this and maybe we're able to correct it, but I see these after the fact on appeal, where the court decides to terminate a parent's right at initial disposition. So they go right from adjudication to termination without any services, which in my view, the statute requires and the Constitution requires that parents get services unless there's aggravated circumstances. And there's court rules about when those aggravated circumstances findings are supposed to be made at the beginning of the case. And for those people in the audience who don't know, aggravated circumstances are really extreme. Like there's been a sexual abuse of the child that involves penetration or attempted penetration. It involves like the death of a sibling, or like serious bodily injury, battery, torture. Like we're talking about, like, this is big bad stuff. And I see this happening in cases that the facts just don't add up to aggravated circumstances, and yet they're terminating at initial disposition without any services because, well, we're just going to do it, and because DHHS requested. I don't know if you've encountered that, but if you have, or how would you turn that around before it gets to appeal?
I guess to some extent, I haven't had to deal with that issue, because one of two things are happening on my cases. If it doesn't get to that level, usually we're able to get termination taken off the table. And, in the cases that we've dealt with, one way or another, wheeling and dealing, we are able to, on those cases where it doesn't have those aggravated circumstances, able to get termination taken off the table, and we can move forward and services are provided. In the other side, those serious cases where we've moved to termination or on initial disposition and there's no services provided, those are cases where, at least the allegations are aggravated, that serious bodily injury. I deal a lot with infant fracture cases, where there's multiple fractures. That's going to qualify as a serious bodily injury. Certainly sexual abuse. Those cases are moving forward. Serious injury. The other termination cases that we have are where someone isn't complying and benefiting from services, and we've gone through, a year, 12 months, 18 months of services, and it's just not working, and then they file that supplemental petition. So they have gotten the services. So I really haven't dealt, at least I'd be interested to hear about some of those cases where you have that, but I don't think I've actually dealt with a case where I felt that I had an argument that this doesn't rise to the level of aggravated services or aggravated injury, and those services should be provided in that time period before that termination hearing at initial dispo.
And the cases I'm seeing, the issue's not being raised in the trial court, and I have to raise it as a plain error issue, which I should have mentioned earlier because it applies to all family law, all custody type cases, and of course child welfare as well. In the recent case of Quint v. Quint, the Michigan Court of Appeals did confirm that the plain error standard applies in civil cases as well when custodial or parental rights are at stake. So that's a pretty important decision. And I
would just add from a practice standpoint, if that happens, like I said, I haven't really had that happen, but If that happens to you and you're waiting, don't sit around and just have them not do services. There are loads of independent services that you can have your client do, both online, in person. If you don't know, call me. I have parenting classes, sex abuse awareness classes for failure to protect issues, alcohol, substance abuse. I can find all those privately, and sometimes those are better because sometimes your contracted service providers are not that favorable to your clients, to the respondents, when DHHS is paying contracted. So sometimes we prefer to do independent services, but we in our office have a host of different places that we use and services that we use, that we send our clients to do those independently of the court. So
Very good
don't sit
point.
around
Thank
on
you.
that. Do not, make sure your client is engaging in services, because remember, you have that best interest hearing, even if the statutory grounds are met, and you can bring all of that to light and say, look, Judge, I understand statutory grounds have been met, but look at all of everything that our client has engaged in voluntarily, and show that plethora of services to the court, and the effort to get them to find that it's not in the best interests, because the parents are making an extreme effort, even if those services haven't been provided by the state.
Well, that's a great point, Brandy. Well, thank you so much for joining us today, and to Andy too, who had to leave 5 minutes early. I hope you all have a good rest of the week, and I'm going to stop the
Thanks, Lisa.
recording.